You're not quite ready for it yet. So today our agenda is to cover Chapter 8, which is agency contracts. If you remember before the snow day last week, we talked about basic contract law, right? We covered basic contract law this morning. Today we want to talk about agency contracts and what those are. What do you think an agency contract is? Well, what's agency? What is agency?
The firm.
The firm is the agent, but what's agency?
The relationship.
The relationship that a firm has with what? A client. So what do you think an agency contract is? The agreement between who?
The client and the firm.
There we go. Perfect. That's a perfect. You see how you start to put all these topics together now, right? We talked about contract law, we talked about agency, now put them together. Agency agreements or agency contracts are the contractual agreement between a real estate firm and who? Real estate client. Why do you think they need a contractual agreement? Say that again. To get paid. To get that? No, you cannot. No. I'm giving you all I'm giving you today. No. We need a contractual agreement so that we can get paid. As a matter of fact, the Real Estate Commission has very specific rules about that. They say that if you don't have a written agency agreement, you are a volunteer. Doesn't that sound fun? It does not to me. Let me ask you a question. Why are you getting a real estate license? So you can pay. So that's the right answer, believe it or not. That's not even the selfish answer. Will you close that, buddy? Or just actually hold on, because not everybody's here yet. So we'll leave it open for a second. The right answer is you get a real estate license to get paid. I ask that question a lot of times. People say, "Oh, I want to sell houses." It's baloney. First of all, do you need a real estate license to sell houses? No. You need a real estate license for what? To get paid to sell houses, right? This is a professional license. The only reason you get it is because you want to get paid. I hear people all the time come in here and say, "Well, I just want to get the license so I can do this for myself." You're wasting your time because you don't need a license to do it for yourself. What does the rule say? And I'm asking this question for a very important reason. Do you think there's going to be test questions where they give you scenarios where they ask you why you need a license, or which of the following would require having a license? You think that might be a type of a test question? Sure it will. So, what's the rule? We need a license to do what? To get paid for doing what?
For buying or for selling.
Buying, selling.
Property for compensation for others.
More than buying or selling though, right? How about leasing?
Yeah, leasing.
Yeah, listing, exchange, anything to do with real estate. Let's just put it that way. Anything to do with real estate for other people than myself, right? Anybody other than myself. Would you agree with that?
No.
And to get what?
Paid.
Paid for it. That's the whole definition when you pull it all together. I need a real estate license if I'm going to do a real estate activity for somebody other than myself, and I'm going to get paid for it. If it doesn't meet any part of that definition, do you need a license for it?
No.
So, can you get paid for doing it if you're doing it for yourself and not need a license?
Yes.
No.
Think about the definition. This is why we have to hammer it into you, right? Because you'll spout it back at me, but you haven't thought about what you're saying. This is not a memorization class. Memorization won't get you there in this class. You have to think about what you just told me. You said the definition of brokerage is buying, selling, leasing, listing, exchanging real property for somebody other than yourself for compensation, right? And so I just asked you, can you get paid for doing it for yourself without a license? What's the answer to that question?
Yes.
Yes, because it's got to be for somebody other than yourself and getting paid that requires a license. Does that make sense? Can you do it for somebody other than yourself for free and not need a license?
Yes.
Yes. It's got to be all of the above. Now, does it matter who the other than yourself is?
No.
No. Is your mama somebody other than yourself?
Yes.
If my mother pays me to manage a property for her, is that a brokerage activity?
Yes.
Even if she only pays me $15 a month to do it, is that a brokerage activity? Does it require a license?
Yes, someone other than you.
It's somebody other than me, and I'm being paid compensation for it, correct? Does that require a license? Yes. You have got to dig into the meaning of these definitions. You've got to stop and think. When it says, for somebody other than yourself and for compensation, and means and, not or. Are and or two different words?
Yes.
When you get on the test, are may and must two different words? A broker may do this versus a broker must do this. So those two entirely different statements. You've got to pay attention to that kind of wording. Though that turning of verbiage is the difference between you passing and failing. It honestly is. Would you agree with that, Annie?
Yeah.
It is. You can know the material. You can sit there and be able to spout that definition back to me all day long. But if you can't sit there and apply it, you can't answer the question. So that's why I constantly throw it back at you and force you to engage with it, because until you're ready to do that, you're not ready for the exam, because that's what the exam's going to do. It's going to give you that kind of a scenario and say, do you need a license for this? And you've got to be able to apply that definition and say, okay, if you're asked, does somebody need a license to do something, what things are you looking for? What are the two things that you're looking for? Number one, are they doing it for other people? And are they getting paid? Does that make sense? Those are the things you're searching for. You got to check off the tick marks. Yes?
I have a question, kind of like sidebar.
Okay.
Is there any practice tests that we can possibly do that is similar to the state exam and not the ones in the book?
Mm-hmm. It's called the midterm.
So that's the only like practice test there is?
Oh, there's plenty of them. You can go out and buy all the ones you want to online.
Oh,
There's
really?
thousands of them. But you got to buy them.
So what one do you recommend?
I don't.
Oh, okay.
I don't recommend one. Because if I was going to tell you to spend your money on something, I would really think it was a good product. Unfortunately, I don't think there are any good products out there. You want the ugly truth? There ain't nothing that's going to prepare you for that test, other than me standing here and screaming it in your face.
Okay.
That's the ugly truth. The closest thing you're going to see are my quizzes. You know how long it takes me to write a quiz question?
Based on what I've seen, it takes
An hour for one question. It's damn hard. You would try it sometime. Try to write a question with that level of detail. It's almost impossible. Because most of the time you write multiple choice questions, the answer's obvious, right? It's very hard to write ones where it's not obvious. That's why there aren't any quality products out there. I wish there were. Because it would be really easy if you could find tests that were like the state exam and just take them over and over and over and over and prepare. They have designed it so you can't do that. They have designed it so you have to have mastered this. This is why North Carolina is the hardest place to get a real estate license. That right there. In every other state, you can go buy those exams online and you can just sit there and practice them and practice them and practice them. Because in every other state, you know what the exam looks like? It looks like the questions in the back of these chapters. How do the questions in the back of these chapters compare to the questions I've given you on my quizzes?
It doesn't even come close.
It's not close. It's not close. It's not close. And so all we can do is sit here and turn these ideas around over and over in your head. So when I'm engaging you asking those questions, if I'm engaging you in a way that you're not comfortable with, that's a good thing. I got to get you out of your comfort zone. I got to make you uncomfortable. I got to make you squirm. I got to make you sit there and think, I don't know that. Here's the thing. It's not because I want you to feel bad. It's because I want to point out to you that's something you need to go back and look over. I thought I knew that definition, and maybe I did know the definition, but I didn't really know what the definition meant. You follow me with that? Because there's two different things, to know the definition and then know how to apply it. Very different things. And so that's why I kind of come back to those topics, because I know the ones that are going to give you a hard time. I know, I've seen over the years, the ones that you know the definition and you can say it for me, but then when I give you the test question, you don't apply it.
Okay.
That's why I pick and choose certain things to come back. I'm running through in my mind mentally, oh, that's something that we need to talk about again.
Okay, gotcha.
Okay? It's a good question. I wish I thought there were resources out there that I could say this is a slam dunk, you should do this. There are practice exams. There are AMP practice exams out there. Personally, I've never had a student come back to me and say, you know, I bought this and I'm so glad I did because it really prepared me for the exam. Now, I have a friend of mine in Chapel Hill who's written a test prep book, and I haven't had a chance to read it. I'm hoping it's better than the ones I've seen before. If it is, I'll recommend it to you.
Well, hopefully you'll pass it and we won't need it. So.
Well, I mean, you know, my goal is always that you pass it. That's why I challenge you on it. That's why I push you. You know, my goal is to get you out of that comfort zone, to make you not think this is a memorization thing, that I've got to really engage with it. That's why we do the little interactive activities with the agency, so that you can start to think about it at a deeper level.
Well, I do think I'm definitely out of my comfort zone.
Good, good, good. If you're comfortable, you're in the wrong place, right?
Yeah.
That's just, I mean, that's the nature of this thing. It is meant to challenge you. And they've done a good job. They've done a good job if that was their goal. Okay? So, agency contracts. We need to talk about what an agency contract is. We've already decided it was a contract between firm and client. We need to dig a little bit deeper than that, though. Talk about the different types. What's commonly found in these agency agreements? What's commonly not found in these agency agreements? Now, one thing I want to point out to you, I handed out as you came in. I gave you the slides for today, of course, but I also gave you something called the exclusive right to sell listing agreement. Everybody get that? I want you to take a look at this thing for a second, because before we get into agency contracts in general, I want to talk to you about this specific one. And we're not going to go through it right now. We are going to go through it, but not right now. But I want to point out to you something that you're going to forget 5 seconds after I say it. So I'm looking at that camera so you can go back and watch it like 100 times. There is no such thing as a standard contract of any kind. How many parties does a contract have? 2. Who are they? Buyer and a seller. If it's a sales contract, is this a contract?
Yes.
How many parties is it going to have?
2.
And what are the 2 parties? Seller and firm, right? Who gets to decide what's in the contract? The parties involved, right? That's what I mean when I say there's no such thing as a standard contract. But lo and behold, here, what have I handed you? One that looks pretty what? Standard. Here's what you need to understand. Suggested and standard are 2 entirely different things. Why do you think we give you something that looks pretty standardized? And why do you think it's suggested? It's common. And it's common because you all aren't as smart as you think you are. I'm not as smart as I think I am. I couldn't come up with this on my own. As a matter of fact, would it be against the law for me to come up with this on my own?
Yes.
Because I'm not who? An attorney. Who do you think drafted this thing? An attorney. This becomes something similar to standardized because it's already out there. It's already been drafted by an attorney. It is very widely used. So we teach it to you because it's the most common one that you would see. Does that mean this is a standardized form?
No.
Does that mean the Real Estate Commission says, use this form? Does that mean the Real Estate Commission drafted this form? Does that mean the Real Estate Commission says you should use this form? Or that we like this form? No. It just means that the Real Estate Commission recognizes that this form is the one that you are most likely to see out there in the real world. And you know why it's the one that's most likely to see out there in the real world? Because it's the one you've already paid for and it didn't cost you any extra money. Would you agree that's a big driving factor for most real estate agents, not having to spend extra money? Because I, as a real estate broker, could I have my own customized listing agreement? Yeah, but I'd have to do what? Hire an attorney to get it drafted. And while there might be things I don't particularly like about this one, I don't dislike them enough to pay $5,000 to some attorney to draft a new one. Does that make sense for you guys? But I can't reiterate this enough because it's going to show up on the exam and you're going to blast past it and drive me crazy. The form standard from the North Carolina Real Estate Commission. Folks, you can stop reading right there. They don't do that. They don't tell you how to run your business. This is a contract between the firm and who? And the seller. Is the real estate commission one of those two people?
No.
So they don't tell you what to put in here. They tell you what not to put in here. They tell you what it's against the law to put in here. But they don't tell you how to structure this thing. They don't make it up for you. Look down at the bottom left. Who does make it up for you? The Association of Realtors. Is there a difference between the Association of Realtors and the North Carolina Real Estate Commission? You better believe there is. Are you getting a license to be a realtor? No. You're getting a license to be a licensee. Now, you may choose to be a realtor. That's up to you, right? Why would you choose to be a realtor? Isn't this an example of one reason why you choose to be a realtor? Because guess who gets to use this form? Realtors. Guess who doesn't get to use this form? Non-realtors. Because people like me who are realtors, we've paid to use this form, right? I pay $1,000 a year to use this form. In addition to other things. Like what? MLS. Like the MLS. But part of those membership dues, that's the reason people join the Association of Realtors, is because they provide these forms. Let me back up one more time. This class is not a realtor class, right? This is a class from the Real Estate Commission. Why did I hand out the realtor form in a Real Estate Commission class? Because the commission doesn't make forms. If the commission doesn't make forms, why bother giving you one particular form? It's the one that's most common. If we're going to teach you a listing agreement, shouldn't we probably teach you the one that you're going to see 99% of the time out there in the real world? And what one do you think that is? This one right here. And the reason it's the one you're going to see 99% of the time in the real world, because if you're selling a house, are you likely a realtor? Because what do you need to list that house in? The MLS. And if you're a realtor, have you already paid for a set of forms to use? Yeah. So the Real Estate Commission teaches this version of the form simply because it's the most common. They figure if they're going to teach one, we may as well teach the one that you're going to see in the real world. That doesn't mean the Real Estate Commission endorses this form. That doesn't mean the Real Estate Commission says this is a good form or a bad form. It simply says this is a form, and it happens to be the one that's most common. Does that make sense for you guys? I feel like I have to do that 20-minute speech because there are going to be so many tests. I'm not harping on that because it's really that big of an issue. I'm harping on it because these are the kinds of things they like to trip you up with on a test. These are the evil little gremlins that lurk in those test questions because they will put throwaway little statements in there like on the form approved by the North Carolina Real Estate Commission. Well, guess what? It's not such thing. That animal does not exist. There is no form approved by the Real Estate Commission because that's not their job. Does that make sense? Everybody with me on that? So I wanted to point that out before we got too deep into these agency agreement things here. Sylvester, let me bring down copies. All right. So let's pick up with Chapter 8, man, and talk about the different types of agency contracts that we have. The basis for our business is the listing agreement. The listing agreement is the absolute foundation of what we do as real estate brokers. Think about it. Would there be any need for buyer's agents if we didn't have any listings to show them? It'd be a waste of time, right? What are you going to do? Hope you find something that nobody's selling. The listing agreement always has been and always will be the basis of our industry. As a matter of fact, remember we talked about agency. We said if you went back in time 30 or 40 years, everybody represented who? The seller. So the only type of agency agreement you would have found 30 years ago would have been a seller's agreement known as a what? A listing agreement. You need to get familiar with using. Nobody. Here's how somebody's going to know you don't know what you're talking about. Oh, that's a seller agency agreement. Nobody in the real world calls it that. I'm not saying that's an inaccurate thing to say, because it is a seller agency agreement, but in the real world, this is called a what? A listing agreement. So you need to get comfortable with that terminology, because that's the terminology they're going to use in the test. Everybody okay with that? They're going to call this a listing agreement, not a seller agency agreement. Even though it is a seller agency agreement, the accepted terminology is a listing agreement. The listing firm represents who? The seller. Good. Good, all right? So, it says here that listing agreements must always be what? In writing. From the very beginning. You cannot represent a seller in any way, shape, or form without a written listing agreement. Now that statement right there is a perfect example of a time when I'll tell you what the rule is and you will completely ignore the rule when you start applying it in the real world. So let's dive into that. What did I say? You can't do what? Can't represent a seller what? Without a written listing agreement. Somebody walks up to you at a party and says to you, you know, I'm thinking about buying a house. And you know that your best friend is thinking about selling their house. Thinking about selling their house. And you say to that buyer that just walked up to you, well, you know what? I've got a house that would be just perfect for you. Would you like me to try to set up a showing? What did you just do? You represented who? The not seller. That's a good one. Did you hear what Jen said? You represented the not seller. And why are they not a seller? Because you don't have what? You don't have a listing agreement. You see what I mean about you got to dive into that rule? If you don't have a listing agreement, can you even talk about the potential for selling that house to somebody? Can you say, oh, I think they would be willing to sell their house? Can you say that? No, absolutely not. Can you put a sign in front of the house that says coming soon? No. And somebody said to me, well, if I put a sign that says coming soon, I'm not marketing the house. Baloney. What did you put out in front of it? A damn sign. Marketing, hello, right? You can't do any of that until you have a written listing agreement. You sure as heck can't put it in the MLS. You need a written listing agreement. You don't ever act like you have the authority to represent a seller without a written listing agreement. Thank you. Is everybody good with that?
Yeah.
Okay. So make sure you understand that rule. Now, we also have buyer agency agreements, because now it's legal to represent buyers as well. With buyer agency agreements, we operate a little bit different. Buyer agency agreement, what does it say up here the first bullet point? They can be what? Oral. Is that different than a listing agreement?
Yes.
Extremely different than a listing. Why do you think we have that different treatment for buyers and sellers?
It's like when you said you would take somebody to see a house maybe once or twice before they can make a contract, so you can order the place to do that.
So she said I may take somebody out to look once or twice before we really have an agreement. Is that going to happen?
Yeah.
That's a really nice way of saying that buyers are a hell of a lot more flighty than sellers. They're wishy-washy. Buyers don't want to commit. This is a nod from the Real Estate Commission to the reality of dealing with buyers. It would be very hard to operate as a buyer's agent if you had to have a written buyer agency agreement before you could even show somebody a property. How many of you have ever been to look at a house with a real estate agent? What would you have said to the real estate agent if they had given you a 7-page written contract that you had to sign before they unlocked the door?
No thanks.
I changed my mind. I don't need to see it. Wouldn't you? Most of us would. It's just a nod to that. The reason that we are given this freedom is because the Real Estate Commission recognizes that buyers are not going to want to commit to a buyer agency agreement in order to just see a property. Well, if I'm showing them a property, in the back of my mind, am I not always trying to convert them into a buyer client? In most cases?
Yes.
Even if it's my listing that I'm showing them, right? Because if it's my listing that I'm showing them, if they're interested in my listing, great. But what am I also keeping in the back of my mind the whole time?
You gotta have that written agreement.
Well, yeah, I'm thinking about a written agreement, but that's not what I'm thinking about. I mean, you got to be honest. The only reason we think about a written agreement is because those folks down there say, I got to have one. That is not what drives me. What drives real estate agents? Money. What do you see when you show that buyer that house? Two possibilities. They're either going to like this house that I'm trying to sell, which is one distinct possibility. What's the other distinct possibility? They don't like it and keep going.
They'll want something else.
They'll want something else and keep going. I can show it to them as what?
Their agent.
Their buyer's agent. You gotta keep connecting the dots, right? Folks, you don't look at a person that comes and says, this would be the dumbest approach to real estate you could possibly imagine. I'm going to go show somebody my listing. They call me off the sign. I'm going to go show them the house. I'm like, I don't like it. They're like, all right, bye. Who does that? What am I going to immediately say to that buyer?
So we found us.
Let me help you find something else, right? I could not have that conversation with them if I didn't have the freedom to have an oral buyer agency agreement. Because even having the conversation with them about, well, what are you looking for? What can I help you find? Am I not already operating as their buyer's agent? Does that make sense for you guys? That's why we have this freedom with buyers that we don't have with sellers, because we need it. The only way to really become a buyer's agent is you kind of have to start representing them for a while, and then they finally trust you enough to actually hire you. It's not like sellers. It's different. You with me on that? Now, just because it says they can be oral for a time, do you think it's a good idea to keep them oral forever?
Oh, no.
What did I say earlier today about agency agreements? I said the Real Estate Commission has a rule that if you don't have a written agency agreement, you are a what? A volunteer. So what does that mean to you? You've got to at some point put it in writing if you expect to get what? Paid. So would it be a good idea to probably transition this buyer agency agreement into writing at some point in your future? Yes, absolutely. And the Real Estate Commission says that there is a specific point in time that has to happen. If you're going to present an offer on behalf of that buyer, then you must have that buyer agency agreement in writing. And I'll tell you why. From this point forward in the class, almost everything is tied to the time of offer. Here's why that's so important. If I have an agreement with Brianne, for example, as her buyer's agent, an oral agreement, who knows about that oral agreement?
Just you and she?
Just the two of us, right? It could only possibly impact the two of us. Would you agree with that? If she wants to make an offer, aren't we involving and engaging with other people outside of that small little circle of just the two of us? So if I call Nick, for example, and say, Nick, I have a buyer who wants to make an offer on your listing at 123 Main Street. Is Nick going to make some assumptions about me and that relationship with that buyer?
Yeah.
He's going to assume that I legally what? Represent them. And he's going to start to treat me as if I legally represent them. And so he's going to treat every word that comes out of my mouth as if it comes from the buyer's mouth. Does that make sense? So, at that point in time, when we have crossed that divide to the other side of the transaction, doesn't it make sense that the Real Estate Commission would say, now you need to put it in writing? If you're going to actually go outside your little circle with the buyer and you're going to start conversing with a listing agent about making an offer, you put that thing in writing. Because you're now holding yourself out there to this other person and saying, I represent this buyer. Well, we better make it so that you really do. Do you get that? Because I want you to understand, I want you to memorize, you got to do it no later than time of offer, but I want you to understand why time of offer is so important. Time of offer is important because that's when you're crossing the divide to the other side of the transaction. And it's important that Nick, and notice how I said that when I called Nick. I said, Nick, I have a what? A buyer who's interested in making your offer. Why is it important, do you think, that I tell Nick that as soon as he answers the phone?
So he knows you represent the buyer.
So he knows I represent the buyer, and why is that important to him?
Shannon didn't say anything about representing.
Exactly. You know how we know, we would warn clients, right? So we also warn other brokers. Hey, Nick, I'm working against you here, buddy. That's what I'm saying, right? If he's the listing agent, and I call him and I say, I have a buyer interested in making an offer, didn't I just declare to him we're at war? In a very nice way. Right? I have to do that. That's a rule. And when I assume the first contact I have with him, I have to make it clear why I'm contacting him. I'm contacting you because I have a buyer who's interested in making an offer on your listing. In other words, don't tell me anything that could potentially harm your seller, because I'm going to do what with it? I'm going to use it against them. You with me on that? Okay? So, point of offer becomes really important from this point forward. All right? So, agency agreements. What should be in there? Well, it's an employment contract. What's the first thing that would be important to you in your employment contract?
Money.
Money. So is this a good place to probably specify how much you expect to be paid in the transaction?
Yes.
Indeed. Absolutely. This is where you want to specify exactly how much you expect to get paid. And is it you personally that's getting paid, or is it your firm? This is where you specify what your firm's going to be paid. What you personally are going to be paid is not going to be on a listing agreement or a buyer agency agreement. Where would you find that? In your employment agreement, your independent contractor agreement with your what?
Firm.
With your firm. Would it be really stupid to go work for a firm and not have a written independent contractor agreement?
Yes.
Do you know that there are thousands of brokers in this state who do just that? And then when they don't get paid on a transaction, or they don't get paid what they think they're supposed to get paid, they go and they try to sue their firm. And the firm walks into court and says, Your Honor, the commission belongs to us. Why would we pay this person? And the broker's going to say, Well, you told me. And the firm's going to say, Show us. Where did we tell you, dear child? We just thought you liked us.
You were volunteering.
Is it a good idea to have a written employment contract, a written independent contractor agreement that specifies exactly what you're going to be paid? I would say if you go and talk to a firm and the first thing, and they don't give you the independent contractor agreement for you to read first thing, that would be the end of the meeting for me. There's a tip when you start interviewing firms. Ask them for their independent contractor agreement. Read through that thing. Don't just sign it. It's going to be 50, 60 pages long. Why do you think it's 50 or 60 pages long? To protect you?
No.
To protect who? That firm. You better believe it. And those details are important that are in there. Would not be uncommon for a firm to screw over a broker. That does happen from time to time. And it mostly happens when brokers are lazy and don't read their agreements. So, there's a tip. Make sure you read it. Because this listing agreement's not going to protect you. Who's it going to protect? The firm. They're owed the commission. If you think you're owed some of it, you better make sure you've got a good independent contractor agreement that specifies what you're going to be owed. I'm not saying most firms would do that, because they wouldn't, but I don't want it to happen to you. I want to make sure you protect yourself. Just like you protect your clients. Make sure you do the same due diligence for yourself that you do for your client. When you read the contract your clients are going to sign, please say yes to that. I've asked agents before, what does the contract say? I don't know, it's new construction. Does the fact that it's new construction mean you shouldn't read the contract before your client sign it? Well, it was 60 pages long. Does the fact that it's 60 pages long mean you... In fact, if I see a contract that's 60 pages long, that makes me want to read it all the more. Because I know if a builder's got a contract that's 60 pages long, is it likely to be good for my client in those 60 pages? No, probably not. Read. Make sure you read those agreements for yourself and for your clients. All right? We talk about when we're owed a commission. This slide specifies a phrase that you're going to need to be familiar with for the test. It says we're owed a commission when we produce what? A ready, willing, and able buyer. Now, let's talk about the difference between the word, like I said, it seems like a vocabulary day for some reason. I said there was a difference between the words may and must earlier, right? Is there a difference between the word owed and collected?
Yes.
Mm-hmm. This says you are owed a commission, or the firm is owed a commission when we produce a ready, willing, and able buyer. Is that when we actually collect the commission? No. When do we generally collect the commission? After closing. After closing. When is it that we have produced a ready, willing, and able buyer? When they go under what? Contract. We've actually performed our function most of the time when we go under contract. Does that make sense for everybody? Therefore, the commission is owed at that point in time. All the years I've been in this business, I've never collected one at that point in time. Why do you think that's an important distinction? Is there the possibility that you could have a commission owed that's not collected?
Seller backs out.
Seller does what?
Backs out.
Seller backs out. So the seller accepts an offer. Have you done your job? If you're the listing broker, have you done your job if the seller accepts an offer? And a week before closing, the seller changes their mind and they don't want to sell. That's called a seller breach, right? Well, the seller's actually breached 2 contracts at that point. They've breached a contract with the buyer. What other contract have they breached? Their agency agreement, their listing agreement, where they promised to do what? To sell. And more importantly, from my perspective, promised to pay if I sold. Did I sell?
Yes.
I did. Not my fault you didn't close. Is a firm still owed that commission?
Yes.
Yes, because the firm has already produced a ready, willing, and able buyer. Does that make sense?
Yes.
What would you have to do to collect such a commission in a case like that? You'd have to file a lawsuit. You got to make a business decision at that point. It won't be you. Who will it be making that business decision? It'll be the broker in charge, because who would be filing the lawsuit? The firm, because it's the firm that's owed the commission. Does that make sense? So these lawsuits don't happen very often, but they do happen sometimes. In the case of a seller just outright backing out, that might be a good opportunity for a firm to sue, because clearly a commission's owed at that point. Does that make sense for everybody? You following that line? This is the reason this is a contract. It's a contract. It's an agreement. They've agreed to pay. All right, is everybody okay with that so far? So ready, willing, and able buyers when the compensation's due. Here's where we talk about things that should be in a listing agreement or a buyer agency agreement. We said that the compensation should be in there. We also want to make sure that we have an expiration date. All agency agreements for sales transactions, so buyer agency agreements or listing agreements, need to have an expiration date. What the Real Estate Commission says is they cannot be open-ended. Does that mean they're limited to like 10 years or 15 years or 20 years or 250 years?
It's a specific date.
It's a specific date. We don't care what the time period is, as long as there is a specific expiration date. The Real Estate Commission is not saying you can't list it for 10 years if that's what you want to do, but you just can't have it be open-ended. You'd have to pick a specific date 10 years from now that this thing was going to expire. Is everybody with me on that? Okay? You need a specific expiration date. You can't just leave a blank line that says, we have the listing. It doesn't work that way. All listings and all buyer agency agreements must expire on a specific date. Other things that have to be in there, and I would star these things because they're going to test you on these things that need to be in these agency agreements. It says that they must have an anti-discrimination clause. All agency agreements need to have an anti-discrimination clause. What does that mean? What do you think we mean when we say an anti-discrimination clause? Who's not going to discriminate? The firm and the brokers will not discriminate against who?
Anyone.
Buyers or sellers or any customers, anybody, on the basis of, we haven't talked about fair housing yet, but there are 7 protected classes of individuals: race, color, religion, national origin, sex, familial status, and handicapping status. Those are the 7 protected classes. Did you memorize them as I went through them there?
No.
We'll do that later in the book. It's a whole chapter on fair housing. But every agency agreement must have that statement in there. It must be clear that why do you think that statement's got to be in there? Is it because the Real Estate Commission is concerned that so let's say we're doing a listing agreement. Is the Real Estate Commission concerned you might discriminate against the seller? Is that why they're making you put this in that statement in there?
No.
Why do you think they're making you put the statement in there? But protect the buyer how? Get deeper than that. What does the Real Estate Commission want to make very clear? They know you know not to discriminate, but who doesn't know?
They can't either.
The client. Who's the client on a listing agreement? The seller. Might the seller expect you to do some discriminatory things?
Yeah.
Are there sellers out there who would expect you to act in a discriminatory manner sometimes? don't sell my house to this person. Don't do that. I don't want this guy because my mama lives next door and I don't want her living next to Could that be a conversation that could potentially come up? So the Real Estate Commission wants to make it very clear to that seller that you're not allowed to do that. Does that make sense? That statement's not there for your benefit. It's there as advertising to your client. Your broker is not allowed to do this. If you want that, don't hire this real estate broker, because we want to make it clear that your real estate broker cannot participate in any sort of discriminatory activity. You understand why that needs to be there, right?
Yes.
Okay, good, good. Also, a listing agreement, a buyer agency agreement, it should identify not only the firm, but it should identify the individual broker who's signing it on behalf of the firm. You're not going to get your broker in charge to sign every listing agreement. It's just not possible. It's not feasible. Who's going to sign the listing agreement on behalf of the firm? The individual broker. Do you think you should put your name and license number on there if you're signing on behalf of the firm?
Yeah.
Absolutely. You need to identify yourself and identify yourself as a licensee. So that's another thing they like to show up on tests. That your name and license number must appear on all documentation. Why do you think the Real Estate Commission's big on that? If they come out and look at that document years down the road, they want to know who to call, right? They want to know whose phone number to pick up. They want who to go after, as Annie said. Exactly. They want to know who to go after. They want your name and license number stamped on everything, even on the closing disclosure. When you go to closing now, and the buyer and seller walks out of there with that financial statement of where the money went and how much money, guess what's over there in the margins? The broker's name and phone numbers, email addresses. In case 10 years from now there's some question. Yes, ma'am.
Is there a rule about how long you have to keep files here?
There is a rule about how long you have to keep files until you die. No, I'm just kidding. It's not that long. 3 years. 3 years. The question was, how long do we have to keep transaction records? And the answer is 3 years after the end of the transaction. Not 3 years from the time you created the record, but 3 years from the time the transaction ended. So in a sales transaction, that'd be 3 years after what? After closing. Now, suppose you've been working with that seller for a year before closing.
Still.
It doesn't matter. It's 3 years from what? Closing. And what records would you keep? All of them. So sometimes could you have records more than 3 years old?
Yeah.
Sure, because if I started working with the seller a year before closing, I've got a whole year's worth of records and I have to keep them for another 3 years after we close. So at some point my records are going to be almost what? 4 years old. Does that make sense? What if I'm a property manager and I've been managing the same property for 25 years?
I keep them
How
all.
many years worth of record keeping do I have to have?
I got them all.
All of them. Because we haven't ended the transaction yet, right? The rule says 3 years after we stop working for that person. So if we've been managing that same property for the same owner for 25 years, we got to have all 25 years worth of record keeping, and we got to keep it all for 3 years after we stop working for that person. Does that make sense for everybody? That was a long answer to your question, but it's 3 years. Now here's the better question. What's a transaction record? Give me some examples.
A listing agreement?
Listing agreement, certainly. What else? Come on, y'all are better than that. What else?
Employment contract?
What kind
Is that
of? So you mean with my firm?
the same? Yeah, sure.
I would say that's not really a transaction record because that doesn't involve my client.
Okay. Yes.
What else? What other things my client going to be involved with?
Well, you said the working with real estate agents. So usually they have all
Working with real estate agents brochure, a dual agency agreement if there's one.
Would it be all emails between you and them and everything?
All my email. You haven't said sales contract yet. How about a sales contract? Would that be a transaction record? Every email I sent to the client, to agents on the other side of the transaction, to inspectors, to closing attorneys, to lenders, offers. So if I'm representing a buyer and they made 6 offers on 6 different properties before they went under contract, which offers should be in that transaction file?
All of them.
All of them, even the ones that didn't get accepted, right? And what emails should I keep? All of them, even to the 5 agents that we never came up with a deal about, right? Do your clients text you?
Yes.
Is that a transaction record? It is. Do real estate agents put their listings on their Facebook pages sometimes? Guess what just became a transaction record? Get used to keeping everything. You write it on a Post-it note, that's a transaction record. Now, does that mean you have to physically keep the Post-it note? No. What could you do with it?
Snap a picture of it.
Snap a picture of it, scan it, whatever. I tell you, I don't keep any paper. I intentionally don't create paper because I don't want to have to hold on to it. I could scan it, but I don't even want to do that. I try to keep everything paperless. But if I do have paper notes, what I do is I keep them in one folder until the end of the transaction, and then all at one time I just go back there to the scanner and just feed it all in one time and name it one big PDF file. It might be 100 pages long. I don't even bother to put it in any order. Just because what are the odds of me needing it? Very slim, right? It would take me more time to categorize each individual transaction than it's worth, because the one that I might need 3 years from now, as long as I can go back and find it at that point in time, yeah, it might take me 20 minutes to find that one piece of paper in there, but that's better than spending 15 minutes categorizing every single file all year long. Does that make sense? You can come up with your own system. It doesn't matter. The big thing is keep it. Keep the record. Every email, every text message, every Facebook posting. So does that mean you might want to think about not sharing your listings on your personal Facebook page?
Yes.
Maybe creating a separate one for your business, because it would be easier to record keep if you could just keep everything off on the business one and not have to worry about stuff that, you know, because now you got to sort through, okay, that's a picture of my nephew, I don't need that. This is a picture of a house I'm listing, I do need that. So let me do a screen capture here. Whereas if you just have a business Facebook page, you could keep everything on there. Make sense? Every record. 3 years after the end of the transaction. Good question. Good question. All right. So things that must be on those agency agreements. Again, we need an expiration date. It can't be open-ended. We need to have that anti-discrimination clause, and they need to identify the individual broker who's taking the agreement, whether it's a listing agreement or by our agency agreement. Now, in your book, as well as in your slides here, we talk about solicitation rules. What we are allowed to do to try to solicit business. What do you think we mean by soliciting business? Like, what are we doing here?
Marketing yourself?
Some kind of marketing. We're marketing ourselves. And what are the ways that we might market ourselves?
Facebook.
Facebook, sure.
Calling.
Other social media, Instagram, Twitter, you know, all those different places. Pinterest. I don't even know what you do on Pinterest. What is Pinterest? Somebody explain Pinterest to me. What is it? I'm dumb.
It's where you put your likes and your likes of different pictures, houses, bathroom remodels, things
Okay.
like that.
So is it different than every other social media
Yes.
platform?
Yeah, it's different. It's really not a
Create boards
marketing
under
tool.
categories, and you can like save pictures and tutorials to different categories.
I don't look at it as marketing.
I'm not going to find out.
But I
My bandwidth is exceeded for social. I don't need another black hole of time to go down. I got enough. Thank you very much. You know, they all are, right? Isn't that what social media is? It's just a black hole to dump your time into. I mean, and it can be a productive use of time, but sometimes, you know what I find, like the analogy I like to use for Facebook is, you ever been hungry at home and know there's nothing in the refrigerator worth eating, but you still go open the door and stare in there for like 10 minutes anyway, like something worthwhile is going to pop up? Facebook's a lot like that, isn't it? Like, you know, you get on there and you're clicking on it, you're like, there's not a damn thing in here worth looking at. You know, I'm going to spend 10 minutes scrolling anyway, right? It's kind of that thing. I think that's the nature of social media to a large extent. You know, it just works that way. But there are other more traditional ways that we market ourselves. Phone calls, right? Telephone has traditionally been used as a how many of you hate telemarketing calls? The worst ever, right? Well, you might be that person one day. As a real estate broker, you're going to have to decide if you want to use the phone as a medium to market yourself. If you do, there are laws. They're supposed to be laws. There are laws you have to know for test-taking purposes. I'm not saying anybody follows them, especially considering the number of telemarketing calls that I get. There are laws called the Do Not Call Registry. How many of you have ever heard of the Do Not Call Registry? Okay? So, the name says it all, right? If you're on that list, people are not supposed to what? Call you. Exactly. Now that rule is going to be part of your existence as a real estate broker. If you're going to use the phone to market yourself, do you think it's going to be important that you check with the Do Not Call Registry first? Absolutely. Because you need to make sure somebody is not on the Do Not Call Registry before you do what? Before you call them. If you call somebody on the Do Not Call Registry, you can be fined. It's a pretty significant fine for making those phone calls. So you need to make sure that you're aware of whether or not somebody's on the Do Not Call Registry. Now, just because somebody's on the Do Not Call Registry doesn't mean you can never call them. There's no such thing as, it would be kind of, wouldn't it defeat the purpose of a telephone if they couldn't be called for any reason? You with me? So just because somebody's on the Do Not Call Registry doesn't mean they can't be called for any reason. It means they can't be called for solicitation. You with me on that? So, we as brokers need to understand where the line begins and ends for what is a solicitation phone call. Does that kind of make sense, what we're trying to do here? We're not telling you, don't ever call these people because they're on the Do Not Call Registry. We're saying, don't call them if you're soliciting them, and here's what solicitation is. Okay, so now let's talk about what is solicitation. Solicitation is calling them to market your services. If you're calling them, and the primary purpose of your call is to market your services, that's a solicitation phone call. What if somebody has their house on the market, FSBO, for sale by owner? Well, what's usually accompanied with that sign?
Someone's
Phone number.
A phone number, right? What if that person is on the Do Not Call Registry?
You can still call them.
You can.
Yeah.
You can call them. For any reason?
No, not for any reason.
For what reason?
Concerning their particular sign in their yard.
And what is that sign there for? Keep talking.
To sell their home.
To sell their home to
So if you
who?
have a buyer-
To anyone.
To a buyer.
To a buyer.
So under what circumstance do you think it's okay to call that
If you're the
person?
buyer's agent.
If you have a buyer. That is the end of where it's okay to call them. Is it okay to call them and say, hey, if you don't have luck selling your house, I'd love to talk to you about listing it with me?
That's solicitation.
That's solicitation. Big difference in those two phone calls. Does everybody understand that? So with a for sale by owner, you can call them for what reason?
If you have a buyer.
If you have a buyer interested. Now, if they're not on the Do Not Call Registry, do you care?
No.
No, you can call them for any reason then, right? If they're not on the Do Not Call Registry, can you call them and say, hey, I'd love to talk to you about listing your house?
Yes.
Sure. Sure. This only applies if they are on the Do Not Call Registry. Does that make sense for everybody? Now, if you don't know for sure, should you assume they're on the Do Not Call Registry?
Yes.
Yeah. If you're not going to bother to check, then the best way to proceed would be to make the assumption that they are indeed on the Do Not Call Registry. Everybody okay with that? That's the best way to handle it. I think to keep yourself safe, make the assumption that they are on the registry. Okay? So, again, FSBOs, why can we call them? Assuming they're on the Do Not Call Registry, why can we call them? If I have a buyer that's interested in their listing. No other reason. How about if I have a buyer that's interested and I also want to solicit my services? Can I do that?
Well, you can say one, but not the other.
One but not the other. See, brokers love to call people who are FSBOs and say, oh, I have a buyer who's interested in your property. Oh, by the way, I'd love to talk to you about listing it. And meanwhile, the buyer just never really materializes. You can't talk about listing the property for them. That's solicitation. Is everybody all right with that? Now, if you go show the buyer the property in person, could you talk to the seller then about listing their property for them? It says do not what? Call. It didn't say anything about do not talk to them in person. So if you indeed do have a buyer and you call and you set up that showing and you take it to show the buyer and your buyer's not interested in the property, could you have an in-person conversation with that seller about listing their property? Of course. This law only affects calling. Are we good with that? Now, there are also other reasons that it's okay for us to call, and you're going to be tested on these. when somebody is on the Do Not Call Registry. It says here that consumers can be contacted for up to 3 months after inquiring about a property. So, if you're a listing broker and somebody calls you and leaves their phone number on your voicemail, is that permission to call them?
Yes.
Even if they're on the Do Not Call Registry?
Yes.
Absolutely. They gave you their number, not the other way around. But that permission's not forever. How long is that permission for?
3 months.
3 months. 3 months. Somebody goes on your website and fills out one of those little forms. I'd like more information. They put a phone number in there. Is that permission to call them?
Yes.
Yes. Do you need to even check if they're on the Do Not Call Registry?
No.
No. Because you have permission to call. For how long?
3 months.
3 months. You need to know that time period. Okay? And then there's another time period. It says consumers who were actually your client, the ones you actually do a deal with, a transaction with, how long do you have permission to contact them via the phone? 18 months. So if I have a buyer client who's on the Do Not Call Registry and I help them buy their house, a year after they close, can I call them and say, you know, by the way, I would really love it if you have any friends who are interested in buying, if you refer me to them. Can I make that phone call?
Yes.
Yes, because as long as I'm within what time period? 18 months. But it's only 18 months if they were actually what? A client. That's different than somebody filling out a form on my website, isn't it? Is everybody okay with that?
Yes.
Okay. Make sure you know these time periods, right? Because you probably see those on an exam, I would imagine. There are also, and I mentioned them just briefly down here at the bottom, laws impacting soliciting via email and via fax. Basically, all you need to know is that those laws exist. The Canspam Act, for example, spam is email solicitation, right? So the Canspam Act is a law that's designed to prevent email solicitation or unwanted email solicitation. How many of you have gotten solicitation emails today?
Yeah.
All of us, right? They should all share one thing in common. If you look down at the bottom of them, what do they have?
Opt out.
They have an unsubscribe link. The law about soliciting via email is much less strict than the law about soliciting for phone calls. Who is the burden on when it comes to phone calls? The person being called or the person making the call? The person making the call. You, as the person making the call, have to check the list first before you call. Does that make sense? When you're emailing, do you have to check first?
No.
No. You just send out the email. It's okay to spam somebody one time. Because what do you have to give them the opportunity to do? Unsubscribe. That's the Canspam Act. Is everybody good with that? And then just know that there is a law regarding junk faxes. I don't know how many people actually have fax machines anymore, but if they do, you're not supposed to junk fax them. I think pretty much only pharmacies have them now, so if you want to spam your pharmacist, you can use a fax machine. Yes,
What
ma'am?
about regular mail?
Regular mail, that's a wonderful question. There are no laws limiting the amount of spam you can send somebody through their mailbox. So as much U.S. postage as you would like to buy, feel free.
Is that why?
I wonder. You think? You think they might not want to gut the postal service?
Yeah.
Well, here's the real thought process there. Why can you send a letter for 50 cents? Is that the cost of sending a letter? You think it costs the postal service only 50 cents to deliver a first class
No.
letter? It costs them dramatically more than that. Why can they afford to do it that way?
There's so many people spending.
Postage.
Because of all that junk that they're also delivering. That junk is essentially subsidizing the postage that you actually send, the things that you actually send to them. All those Amazon purchases you make, who does Amazon primarily use for delivery? The U.S. Postal Service. You know why? Because they're the cheapest. You know why they're the cheapest? Because of all that junk. That's what's paying freight for it. And that's why there will never be laws that will limit the junk sent through your mailbox. Because if there was, you know what it would cost to send a letter? Check what UPS will charge you to send a letter. Check what FedEx will charge you to send a letter. Instead of 50 cents, try $10. Because, you know why? Because they're not sending junk. That's the real cost of delivering that stuff. And so you will never see a law that will limit it through the mailbox because it would dramatically raise the cost of sending other stuff. Yep.
What about text messages, those fall under the do not call?
That's a good question, and it's actually a question that kind of remains unanswered. Jen's question was, do text messages fall under the do not call registry? I would say yes. This is not settled case law at this point in time. People have made court cases out of the fact that they think text messaging and voice calls are two entirely different things. Of course, there are other people, like consumer advocacy groups, that say they're the same thing. I would say for you to be safe, treat it like it's a do not call. You know, I would say do not call equals do not text as well, just to be safe. Anything with a phone number. Yeah, because it is the same phone number, ultimately. All right, is everybody good on the do not call registry here? Okay, good. Now, you need to know about working with brokers in other states. Referrals. You might want to just write that word on this slide. Referrals. What is a referral fee? What's a referral, and then what's a referral fee?
When you pass along a client to someone, to another broker.
That's a referral. When I pass a client along to another broker. Everybody agree with that? What's a referral fee then?
Being compensated for.
Being compensated for
The
the referral. So, if you put it all together, what we're talking about here is a situation where one broker passes along a client to another broker, and in exchange for that, gets what? Gets paid, usually some portion of any commission that results from the referral. Does that make sense for everybody? Why not just represent them yourself?
You may not have a license in that particular state.
So what you're saying is I could potentially refer somebody to a broker in another state?
Yeah.
Oh. Would that allow you to make money in other states where you don't have licenses?
It would seem like
It does. Absolutely. How many of you have friends and family in other states? How many of you know friends and family in other states who have bought or sold real estate in the last few years? How many of you would be interested in referring those people to a broker in that state and collecting some percentage of the commission on that transaction for doing nothing more than making a phone call? Welcome to the wonderful world of the referral fee. This might, sincerely, be the best thing about having a real estate license. Because you're doing nothing but making a phone call. And you're doing it in a state where you don't even have a license. Now, because you can do it in other states, can other states do it here?
Probably not.
They can.
They can?
They can. I can compensate an out-of-state broker who gives me a referral. So, let me give you a hypothetical situation. Let's say that a broker in Virginia Beach calls me and says that her sister's relocating to Raleigh and would like to purchase a home. And she's looking for a buyer's agent. And she found me on the internet, and she has researched my business, and she thinks I'd be a good fit for working with her sister. And I said, well, great, I would love to help your sister. Of course, I know what's coming next, right? The thing that's coming next is, well, that would be great. Would you be willing to, what?
Pay a referral.
Pay a referral fee, and there's probably going to be a specific number attached to that because we need to negotiate what that amount is going to be. So let's just say, hypothetically, she says, would you pay me 25% of the commission as a referral fee? And I would say yes to that. And so we would have a referral agreement. Does that make sense for everybody? So now she's going to send me, if she's smart, she's going to send me the referral agreement first, before she sends me the sister's name, if she's smart. Now, I would never try to screw her, but I'm not saying other people wouldn't. So there's your lesson in life, right? If you're going to give somebody a referral, make sure they sign what first? The referral agreement, because once you've given them the name, you can't put that toothpaste back in the tube. They've got the name, they're going to call, and they're going to say you referred them, and you're off to the races working with that client, and now you don't have anything saying you're owed any money. So I would get the referral agreement first if I were you. So let's assume we do that. I sign a referral agreement saying that I will pay her firm, not her personally, right? Because remember, compensation always goes where? To the firm. So I will pay her firm 25% of the commission earned on the transaction here in North Carolina where she does not have a license. Does everybody understand what's going on here? And that's all well and good. Here's the one problem that you can potentially run into there. The North Carolina Real Estate Commission does not differentiate between referral fees and commissions, okay? Here's the way the Real Estate Commission views referrals. They view it as a brokerage activity. But what the Real Estate Commission would say about that is it's fine because that broker's not practicing brokerage in North Carolina. What brokerage activity is the Virginia broker rendering? They're doing what? What brokerage activity is the sister doing? She's what? Referring. So the phone call is the brokerage activity. Would you agree with that? And where is that taking place? In Virginia, where she has a license. So the activity that she's being compensated for is happening in the state where she is licensed in. Are you starting to see a potential pitfall here? What happens if she gets in the car with dear sister and comes down here when she's looking at the houses? Now what state is she in? Does she have a North Carolina real estate license? No. Is she rendering brokerage service in the state of North Carolina now? Even if she's not doing anything but tagging along, folks, if that transaction is still going on, the North Carolina Real Estate Commission says she's doing brokerage in the state of North Carolina, and therefore, can she be compensated? No, because she doesn't have what? A North Carolina license. And guess what? It ain't going to be her that the North Carolina Real Estate Commission goes after when that referral fee gets paid, because she doesn't have a license in North Carolina. Who is the North Carolina Real Estate Commission going to go after when that referral fee gets paid? The North Carolina licensee who paid the referral fee. So, if you take a referral from an out-of-state broker, what do you think you have to tell them when you agree to pay that referral fee? Stay in your lane. Actually, you don't have to stay in your state, just don't come into mine. And you don't come here for any reason. You don't come here to buy a scratch-off lottery ticket, to fill up your gas tank, to drive through North Carolina on the way to Florida. Nothing. You don't change planes at RDU. Because if they enter this state, from the time they give you that referral till the time it closes, you can't pay it. That's the rule. And it's up to you to tell them the rule.
Well, then how does that work up on the lake when we're 5 miles from the Virginia line across the lake?
Well, what should they probably do?
Go to Virginia
And
stay in Virginia.
get a Virginia license and a North Carolina license. When you live in an area like that, and you work in an area like that, you should probably have both licenses, because you could easily cross those lines at any given time. Does that make sense? Yeah. Now you know what your next challenge is going to be, right?
It'll be easier.
Welcome to Virginia. I hear it's for lovers, I don't know.
Why wouldn't you just put that in your agreement?
Why would you? Probably be a good idea to put it in your agreement. You are not allowed to enter the state of North Carolina at any time from the time we have this phone call till the time this transaction closes. And if they say, well, that's crazy, we'll say, that's the law here. You know, I'm only trying to keep you and me out of trouble.
And get you paid.
And get you paid,
Yeah.
most importantly. So so that brings me to the question. If you showed up to meet with that buyer and show them houses, and the broker sister was with the buyer, what do you got to tell the broker sister? I cannot pay you.
Can't pay.
I'm sorry. I realize we have a referral agreement, but you have violated North Carolina law by being here in the state, and therefore I cannot pay you. Everybody understand
So
that?
they can't come to the state for anything.
No reason at all
Hopefully we got the.
during the referral. Now, of course, once the referral's over, they can. And they can come to the state all they want to, they just can't come and get paid. Because the only way to be in this state and get paid in this state is have what? A license in this state.
So in essence, they better not be seen coming through North Carolina.
Correct, right. You can't police it. But if you saw them, if they came to the showing, would that be a problem for you?
That would be a problem.
That's a problem. So this really becomes a concern when you take referrals from neighboring states. Because there's a pretty high likelihood that they come into North Carolina at least somewhat regularly. I mean, can you imagine, for example, you're a broker in Charlotte, and you take a referral from somebody in Fort Mill, South Carolina. How many people in Fort Mill, South Carolina enter North Carolina on a regular basis?
A lot.
All of them, because there's nothing in Fort Mill. They go to Charlotte, right? They have to cross that state line to get into the 21st century. There's a rule there somewhere about, yeah, sorry, South Carolina folks, I can't help it, it's just too easy, right? But they probably come into North Carolina all the time. Would you agree with that? If you take that referral, should you have that conversation with them?
Yeah.
Because again, who's the North Carolina Real Estate Commission going to hold responsible for this rule?
Me.
The North Carolina licensee. They're not going to penalize the person in South Carolina. They don't have any jurisdiction over them. But they have jurisdiction over the one in North Carolina who's paying the referral.
So, you need to have that in writing, because if the person that referred it, if they try to sue you, you need to have it in writing.
To show that you told them they couldn't do that.
I would snap a picture and they show up at the show.
Or snap a picture, absolutely. And honestly, it's not going to be that you don't want to pay them. I've never had this come up where somebody didn't want to pay the referral fee. It's probably going to be ultra painful not to pay them. But you can't risk your license to pay them.
Right.
Because that's ultimately what you're doing here. You would be risking your license to pay them if you knew they had entered the state.
Is that really universal, or is that just a North Carolina thing?
Well, see, and that's where you have to realize that this is a great question. It actually leads me into the next thing I was going to say. Real estate license law is different state to state. So, that may not be the same rule if you're the one getting the referral. So, like, for example, reverse the gears, right? Let's say it's me here in Raleigh referring to a broker in Virginia. I have no idea if Virginia has that as a rule. Who would I rely on to tell me? The Virginia broker that's paying me the referral fee. My guess is that most states have a very similar rule. Why do you think this rule exists? Be as cynical as you can possibly be.
Why don't you come in there and taking our money?
But say that again.
They want you licensed.
They want you licensed in both states. The state of North Carolina wants them to get a what? A North Carolina license, because that's a license fee, it's an application fee, it's a renewal fee. You know, they want the revenue stream. So they're going to make it as difficult as possible to make this happen. Because their response is, well, it's simple to fix that. Just go get what? A North Carolina license. And I've actually had this come up one time in my career. I had it come up, I had a broker in Tennessee who gave me a referral, and I told them not to, and they showed up. They showed up at the walkthrough, day before closing. Is that during the time period between the referral and closing?
It is.
It is. And I said, listen, I can't pay you unless you get a North Carolina license. Well, I'm not getting a North Carolina license. I said, then I can't pay you. I said, so, listen, I'm happy to hold this commission and give you time to get a North Carolina license. And it was like a $3,000 referral fee. You know what they did?
Got their license?
They got a North Carolina license. Because they found out it was worth the $3,000, but I couldn't pay them until they got it. I said, as soon as you show me a North Carolina license, I'll cut you the check. Took them 6 months. I held it for 6 months. But I wasn't going to pay it until I knew that they had a lot more, because they were clearly here before we. Does that follow for everybody? It becomes your responsibility. Obviously, you can't police it. Nobody's expecting you to go camp out at the border and make sure they don't cross on 95. But if you know they're here, and the bigger thing is, like Brian alluded to, put it in writing up front, right? So that you've made it clear to them that they're not allowed to enter the state until this transaction is ended. Is everybody good with that? All right? Good. Good.
I have a question.
Okay.
So, I know the Real Estate Commission does not deal with money at all. So, like from your personal experience, does the firm still get like a percentage of the referral?
Yeah, so your question is it traditional, conventional, and it's funny you ask this question right now because we're about to go to the antitrust screen, which is where we're not supposed to say things like traditional, conventional, normal, yada, yada, yada. But your question is a good one. Generally speaking, most firms treat referral commissions no different than any other commission. They would simply apply whatever split you had with your firm to the incoming referral fee as well. So if you had a 75% split with your firm, then you would get 75% of the referral fee as well.
Okay.
Generally speaking, they're going to treat, most North Carolina firms but just treat referrals as the same as any other commission coming in.
Okay.
Right? So that brings us to antitrust laws. As real estate brokers, we have to be very careful of antitrust laws, monopoly laws, price fixing laws. it all has to do with how we talk about things. This is a major test topic right here. This slide is probably good for 3 or 4 test questions written in different types of ways, okay? So, when we talk about antitrust, what you need to know is that the vocabulary you use when you're talking about commissions matters a lot. Don't say things like the normal commission or the standard commission. Don't say anything comparing what you charge to what other people charge. Let me say that again. Don't ever make a statement comparing what you charge to what other people charge. I'm going to give you 2 different statements. One's okay and one's not. Our firm charges 6% listing commission.
That's good.
Our firm charges 6%. I know some other firms only charge 5%, but we include this in our listing that they don't include. Can I say the second one?
No.
Why not?
Because you're comparing with others.
And when I compare with others, I make it sound like those are the only 2 options, right? 5% or 6%. Are those the only 2 options? No, because commissions are what?
Negotiable.
They're negotiable. They're always negotiable. Now, can my firm have a set commission?
Yes.
Of course. People say, well, that's not negotiable. Sure it is, because the client can do what? Go somewhere else. Are cars negotiable when you go to a car lot?
Yeah.
Sure. Do they have a bottom line number where they're not going to go any lower than that? Yeah. And is that still negotiable? Sure it is, because the negotiation is that the buyer can do what? Walk away. They don't have to buy. So yes, your firm can have, I can have a firm policy that we will never charge less than 5% on a listing. That is entirely legal for me to have. What I can't have is a firm policy where we compare what we charge to what other firms charge. And any sort of a statement that, well, most firms charge this. Is that comparing me to other firms?
Yes.
Yes. Well, the normal commission is 6%, but we only charge 5%. Is that comparing me to other firms? Yes. All of that is off limits. Okay? Are we good with that statement? You can't make any of those sort of comparison statements. What you can say is, this is what I charge. This is what my firm charges. This is what we charge. And stop right there.
What if they ask you what all that firm is?
Then you say you'd have to talk to other firms to find out. Because you can't talk about what other firms charge, because that's not your firm. You can only talk about yours. Don't make statements that say, save thousands of dollars over other firms. I know you see it. It's against the law. It's against the law. And real estate brokers have been fined for it by the federal government. Real estate brokers have gone to jail for it. There was a famous case in South Carolina, actually, where a group of local commercial real estate brokers used to have breakfast at Denny's once a month. They had like a monthly little breakfast gathering of all the commercial brokers in town. And they would sit in there, and of course they would talk about the market. Well, apparently there was a new firm in town that was undercutting people on commissions. They were charging less than what these folks were charging. And so they were having these little monthly meetings, these get-togethers, and one of the constant topics of conversation was, well, you know, this guy's only charging 4%. What can we do? You know, well, if we don't sell, if we don't show any of his properties, then he'll go out of business soon enough, and we won't have to compete with that. But what they didn't know was that there was a field rep from the local FBI office who also ate breakfast at that Denny's almost every single day. And after about 3 months of overhearing these conversations, he charged every single one of them with felony price fixing. And they were convicted. That is not pretty, okay? Don't ever make statements comparing what you charge to what other people charge. The other thing that you'll see on the test, the real estate commission has nothing to do with money. It's an interesting dynamic because they're the real estate commission. Guess what they don't regulate? Commissions. So, any test question where they say things like, well, the real estate commission says that your maximum commission can be this. Is that a true statement? No. The real estate commission says you must charge at least this, or you can't charge more than that, or your commission should be standardized for this. Is any of that true?
No.
Because the real estate commission doesn't regulate the money at all. Ever. Can the real estate commission fine you? No. No. Never. Never can the real estate commission fine a licensee. What's the one time the real estate commission can fine someone? Timeshare developers. That's it. Not licensees. Never licensees. No. Can the real estate commission fine a real estate firm?
No.
No. The real estate commission tell a real estate firm they have to refund a commission. What do you think? No.
Still money.
Your real estate commission say, well, you cost this client $10,000, pay him $10,000. No. Whose job is all that? The court system, not the real estate. What can the real estate commission do disciplinary-wise?
Revoke your license.
Suspend your license, revoke your license, reprimand you. That's the only three options. That's it.
What do they do when they reprimand you? Just tell you, hey, don't do this anymore. Like,
Yes, and they put your name in the slammer. It's called the Real Estate Bulletin. They publish a quarterly newsletter that goes out to every broker in the state, and anybody who's had any disciplinary action, including a reprimand, is put in the bulletin. And it's the only part of the bulletin that most brokers read. And I'm sure you can believe that's true, right?
Yeah.
And so when the bulletin comes out, everybody goes to that section. And it's funny, it used to be on the back. And so everybody got it, and they would just flip over to the back. So then they started to get sneaky about it and try to put it in the middle to like force you to read the other stuff that's in there. So you had to like go to, now it's digital, so everybody just scrolls past everything until they get to the disciplinary action. But so that's what a reprimand is. It's a slap on the hand, don't do it again, but it's also the public embarrassment of, and don't forget the power of Google. If somebody Googles your name, guess what's likely to come up?
Yeah.
That bulletin with that reprimand right there. And it'll say, by consent, the North Carolina Real Estate Commission reprimanded, blah, 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 on this date. And then it details why they reprimanded them.
oh wow.
It's also a good way to like kind of learn what not to do.
It is a great way to learn what not
by
to do.
example, basically in a way, bad example.
That's exactly right. Well, sometimes bad examples are the best ones to learn from, right? Because you can pretty quickly get an eye for what kinds of things the Real Estate Commission is looking for, what kinds of things they discipline for, and what kinds of things they get complaints about. Because ultimately, they only discipline for things they get complaints. There's no police force over there. You ride over there, there's not some cars they're not sending out inspectors looking around, They investigate complaints. So if you look at what the disciplinary cases are, you pretty quickly get an idea of what things people complain about, and then what things the commission takes action on. They almost always center around money or failing to disclose things. Money being trust accounts, the mishandling of trust accounts, particularly in property management.
Yeah, it's huge.
Because if you think about a property management trust account, your family runs a property management company, right? How many properties you guys manage?
Just over 100.
Just over 100. Residential? You collect tenant security deposits?
Yes.
What's the average tenant security deposit? $1,000?
Yeah, $1,000 probably average. Yeah.
$1,000. You got 100 units you're managing, right? Do the quick math. How much is that in tenant security deposits? $100,000 sitting in a trust account. Is that tempting if you are managing that trust account?
Yeah.
$100,000 that literally does nobody any good ever. It just sits there and stares at you month after month after month. Meanwhile, your car is broken down and you don't have the money to fix it. Is that a very large temptation? It is. It must be, because people bite that apple all the time. Because if you look at those disciplinary actions, that's where they come from. Taking money from that trust account, borrowing money from that trust account. It's not good. It's called a trust account for a reason. They trust you that the money will be there when it's supposed to be there. But yeah, you can certainly look at the disciplinary actions and get a really good idea of the things that people do that get them in trouble. and they center around failing to disclose things, disclosing them incorrectly, and taking money or mishandling money. You know, we could just say they don't necessarily have to be taking it, just mishandling it. You know, not labeling it properly, not documenting it properly. You know, a lot of times the real estate commission will come in and look at somebody's trust account, and they can't really tell if it's short or over or what. And you're going to get disciplined for that. You may have exactly the right amount of money in there, but if your document keeping is so bad that you can't tell how much money's supposed to be in there, they have no choice but to discipline you. Because you're supposed to be able to tell instantly. If I manage a trust account, and I don't any longer, thank God. If I manage a trust account, I should be able to tell you within 2 or 3 minutes exactly to the penny how much money should be in that account without actually and I don't mean going to a computer and pulling up Bank of America online and looking. I mean I should be able to look at my own record keeping, my own ledger sheets, and tell you to the penny what is in that account. And then if you go look at Bank of America, those two numbers better match.
Yeah.
Then you're managing a trust account.
Yeah.
It's a lot of work, especially in property management.
Yeah, it always feels like we waste so much paper because we keep documents of just everything. We take a picture of everything, every check that comes through, everything.
Yep.
And it's just amazing how many files we have just based on duplicates of information and stored in different spots.
Well, just to give you an idea, every check that they deposit for rent every month, they have to keep an image of the front of the check, the back of the check, the front and back of the deposit slip used to deposit the check, and then the front and back of the check issued for the rent going out to the owner of the property, and the front and back of the check used to disperse their property management portion of the check. So one rent check coming in is 4 records that you have to keep every month for every property, and you're managing 100 of them. It's a lot of record keeping. A lot of record keeping. I'll never do it again if I can help it. I'm not a property management guy. It takes a certain personality type to do that. You know, you have to be really into record keeping and paperwork, and that's never been what I want to do. I can do it, but I don't like it.
It's been a big learning curve for me.
Yeah, it's tough.
It's
tough.
It's hard.
Are we good on this antitrust stuff? So we never do what? We never make what kind of statements? Comparative statements. Any comparison statements about commissions or money. You talk about what you charge, not what your competition does.
I have
Okay?
a question.
Yep.
You said vocabulary matters a lot. Don't make statements saying standard or
Normal or average or regular or everybody else charges this, because those are all kind of comparative statements.
okay.
Because if I say something like, if I say to you, I'll be glad to list your house for you. In fact, I want to charge you 5%. Everybody else is going to charge. Everybody else is going to charge you 6%. What's the message? Don't bother shopping around, because what you're going to find is what? 6%. I'm already giving you the best rate. Is that the truth? No. They don't know. There's probably somebody out there who will list it for 4%. Is everybody else going to charge them 6%? Like every other broker on the whole planet is going to charge them 6%? And if they did, wouldn't it seem awfully suspicious that we were all charging the exact same thing? This is why real estate brokers are constantly targeted for this sort of prosecution, because you start looking around, it does become scarily similar what different brokerages charge. Why do I say 6% a lot?
That's not standard.
That's
but
the not
common.
standard. Oh, she's being careful about it, right? It's the not standard standard. Yeah. And so we have to be very careful not to use that language about it. Is that, you follow that? That's the reason. All right? And then we talk about co-broker transactions. Now remember, what did we say was happening in a co-broker transaction? Two firms, one represents the buyer and the other represents the seller. And what are they cooperating on? What's the cooperation? The commission, right? They're splitting the commission. So we're going to introduce in this chapter commission split math as well, and talk about how to do the math of splitting commissions. Because co-broker transactions, you need to know how those commissions are going to be chopped up into much smaller pieces. But with a co-broker transaction, there's vocabulary here that you need to learn that's going to be very important. The cooperating firm, you have two firms in a co-broker transaction. Agree with that? The one that represents the seller, what do we call them? The listing firm. The firm they are cooperating with, who would presumably represent who? The buyer, we call the selling firm. That is very confusing terminology. That the firm representing the buyer is called what? The selling firm. Okay? The firm representing the seller is called the listing firm. The firm representing the buyer, the cooperating firm, is called the selling firm. That's just going to be vocabulary you have to memorize. You just have to go it over and over and over and say selling firm, buyer, selling firm, buyer, selling firm, buyer. Because they're going to use that on the test. And if you read it wrong and think you just read seller instead of selling, are you going to be backwards in the transaction? Especially when you're doing a math question where they're saying the listing firm is keeping 60% of the commission and the selling firm's getting 40%. If you think selling means seller, are you got the numbers? Do you have the numbers mixed up?
Yeah.
Be careful with that terminology for sure. Okay. And when you have cooperative agreements, and we'll talk about this when we go through the exclusive right to sell listing agreement as well. When we have these cooperative agreements, the listing agreement is going to specify how we cooperate. It's going to tell us how much of that commission is going to be shared with a firm who brings us a buyer. All right? So let's take a break, and when we come back, we're going to dive into the different types of listing agreements. All right? So let's take like a 10-minute break, and then we'll come back.